Do you think Axel Rudakubana's sentence was too harsh, too lenient, or fair? This case of Axel Rudakubana has sent shockwaves across the UK. His crimes, the brutal murder of 3 young girls and the attempted murder of several others, have been described as one of the most heinous crimes in recent memory. So let me explain in this post what offences did Rudakubana plead guilty to, how Rudakubana's sentence was worked out by the sentencing judge, and why Rudakubana's sentence does not mean he will automatically spend the rest of his life in prison. I'm also going to explain what criticisms have been levelled at this sentence, and 4 are going to be mentioned, and what are the suggested law reforms to sentencing law and practice. Please do comment on whether you think the sentence of Axel Rudakubana was too harsh, too lenient, or fair. And don't forget to subscribe and follow for more. So why did this crime shock the country? On the 29th of July 2024, the town of Southport was devastated by a series of brutal stabbings. Axel Rudakubana, then 17 years old, a teenager, murdered 3 young girls attending a dance class and attempted to murder 10 others, including children and adults. The sheer cruelty of the crime, targeting innocent and vulnerable victims, young children, have left people across the country shocked and angry. So what offences did Axel Rudakubana plead guilty to? On the first day of his trial, even before the jury was sworn in, Rudakubana changed his plea and admitted to all 16 charges in total. Murder of 3 young girls, attempted murder of 10 other people, 8 children and 2 adults, possession of a knife on the day of the stabbing, production of biological toxin, ricin, and the possession of tea material. And please forgive me for using that letter to avoid any issues about the algorithm. So what sentence did Axel Rudakubana receive? Mr. Justice Goose, the sentencing judge, sentenced Rudakubana as follows: to counts 1 to 3, murder, custody for life with a minimum term of 52 years minus the 175 days he spent already in custody before being sentenced. To counts 4 to 11, attempted murder of children, minimum term 18 years, less time served. Counts 12 to 13, attempted murder of adults, minimum term 16 years, less time served. To count 14, having an article with a blade, 18 months custody. Count 15, production of biological toxin, 12 years custody. And to count 16, possession of a document likely to be useful to a person preparing an act of tea, 18 months in custody. In total, Rudakubana must serve 51 years and 190 days before being eligible for parole. Justice Goose, the sentencing judge, noted it is highly likely you will never be released. So why did Axel Rudakubana not receive a whole life order? In other words, why does life for Rudakubana not mean a whole life order? Why does he have a chance, a very slim chance of parole after serving that minimum term in prison? This is because the judge has followed the legal framework to sentence an offender for murder under Schedule 21 of the Sentencing Act 2020. A sentencing judge can sentence an offender for murder to a life sentence with a whole life order, meaning life means life. But a whole life sentence order is not legally possible for Rudakubana because he was 17 at the time of these horrific murders. Schedule 21 says that an offender who was less than 18 years old involving the murder of 2 or more persons is 27 years, Schedule 21, paragraph 5.2. However, this baseline and minimum starting point of 27 years can be adjusted for under 18s based on aggravating and mitigating factors of the crimes committed. In Rudakubana's case, the sentencing aggravating factors were multiple victims, including very young children, premeditation and planning evidenced by the writing production and the tea material, use of a knife in a public setting, severe and lasting psychological harm caused to survivors and witnesses. Now, the mitigating factors were Rudakubana's age. He was 17 at the time of the offence, a teenager, and there are reports he was suffering from a mental health condition, although this is not clear from the reports I've read. Despite his age, the aggravating factors significantly outweighed the mitigating ones, reflecting the severity of his intent to kill and the plan to target very young and vulnerable children. Consequently, Justice Goose, the sentencing judge, increased the starting point from 27 years to the minimum term that Rudakubana has to serve in prison, which is 52 years, which he needs to spend before he's eligible for parole. Now, taking into account the time served in total, Rudakubana must serve 51 years and 190 days before being eligible for parole. Now, there has been obvious criticisms of this sentence. One, the local MP for Southport has criticised the sentence as unduly lenient. Two, the leader of the Conservative Party is calling for a change in the sentencing law to allow judges to be able to pass whole life orders, something which this judge said he would have done if Rudakubana was 18 and over at the time he committed these brutal crimes. Three, the sentence should have been consecutive sentences to reflect the multiple victims rather than concurrent sentences, that is, to be served at the same time. And the fourth criticism is that some are calling for the return of the death penalty, something that was abolished in the 1960s. In conclusion, the sentence handed to Axel Rudakubana has sparked critical debates about sentencing law and practice, but also about state accountability, as well as the handling of those who show violent tendencies like Rudakubana, and what local agencies did or did not do, and how do you stop false information circulating of cover-ups and demonization of minority groups, which directly led to the riots and terrorism as seen in the summer of 2024. While the sentencing has been delivered on Axel Rudakubana, it does leave important questions for all of us as a society and for the legal system to address. Can we prevent such horrible crimes and tragedies in the future? And if so, how? Feel free to comment and follow for more.